Commissioners here, Mr. Chief Justice Ma, Secretary Cheng, Lord Collins, and honourable members of the judiciaries present at this conference, Your Excellencies, and members of the diplomatic and consular corps, eminent experts, distinguished guests. Welcome. Welcome to the Global Conference commemorating the 125th anniversary of the Hague Conference on Private International Law, or as we like to call it, the HCCH, an anniversary we decided to honor not by celebrating the past, but by looking into and by embracing the future of private international law and this very honorable organization. My name is Thomas John. I am the attaché to the Secretary General of the Hague Conference on Private International Law, Dr. Christophe Bernasconi. I will be your host for this exceptional event, and I'm very humbled and I'm very honored to fulfill this role, as it is not every day that I have the opportunity to MC the celebration of 125th birthday. But ladies and gentlemen, just to start off lightheartedly, let me take a very simple poll. By a show of hands, many of you traveled at least 2 hours. Can you just raise your hand if you traveled more than 2 hours? Mm-hmm. Those of you who traveled more than 4 hours, keep your arms up. Those of you who traveled more than 6 hours, keep your arms up. Thank you. Ladies and gentlemen, as you can see, this is truly a global conference, aptly entitled the HCCH 125 Ways Forward, Challenges and Opportunities in an Increasingly Connected World. And in many events, this event is exceptional. It is exceptional in the sense that we have attracted the preeminent experts in this area, many of whom, as we just saw, traveled from the far corners of the globe to discuss the opportunities for, as well as the challenges to, private international law. The organizing team envisaged, and we are confident that we will, that this attracts diverse conversations and discussions over the coming 2 days. We also had an exceptional response to our call to join us for these discussions. And in addition to the many familiar members of the HCCH family, we are privileged to welcome so many new additions to it. Your response to our call is clear testament that the interest in private international law grows daily in an ever more connected world. And we convene in an exceptional city. Of course, that we are here in Hong Kong is not merely coincidence. Hong Kong is traditionally vibrant, is global, and colorful customs and international exchanges thrive here. We know that we are in the right place. Ladies and gentlemen, the organizing team hopes that you will enjoy the next 2 days and that collectively we explore, debate, and develop great opportunities that private international law can offer. And on behalf of the HCCH, may I express that we are eternally grateful for your presence at and your participation in this event. Ladies and gentlemen, before we start, let me make 3 short, I think they're referred to as housekeeping announcements. First of all, as part of your essential reading list, as part of your program package, you will actually find the program in this package and you will find the biographies, and I encourage you to take the time to read up on the expertise of all our experts, as well as the list of participants, which is also included. The second is Hong Kong University is a leader in sustainability and the protection of the environment. plastic bottles are normally not allowed at this venue. But we got dispensation from the university for this one event on the condition that we recycle everything. So you will find strategically positioned around the place, I have here plastic bins or recycling bins. I think they're actually more bags that hang on doors. But I would really like you to be environmentally wise and recycle your plastic bottles by putting them in there would greatly help us. And third, I'm sure that's not just only of importance to those who traveled more than 6 hours. The first coffee break will await you downstairs at around 3:45 when we break for the first time after a photo shoot. I will welcome you separately for that later on. But now, ladies and gentlemen, it is my great pleasure to get this opening of the conference on its way. And I ask you to join me in welcoming Mr. Feng, the Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong SAR. Commissioner Xie took office in Hong Kong in June 2017, and in his exemplary CV in both the legal and government fields, you may find at page 7 of the program. Welcome, Commissioner.
The Honourable Chief Justice Geoffrey Ma Tao-li, Secretary for Justice Teresa Yeuk-wah, Dr. Christophe Bernasconi, Secretary General of the Hague Conference on Private International Law, distinguished delegates, ladies and gentlemen. Good afternoon. Hong Kong now embraces a most agreeable, warm and flowery season of mid-spring. I'm pleased that the Hague Conference on Private International Law has chosen Hong Kong as the venue to celebrate its 125th anniversary. On behalf of the Chinese government, I wish to extend a warm welcome to all the participants and offer our warmest congratulations to the Hague Conference for its 125th year, 25 years of history. This conference is themed Ways Forward, Challenges and Opportunities in an increasingly connected world. This is indeed a most relevant theme for discussion. It is also a thought-provoking question for all of us to think about really hard, especially for those working on international affairs. An increasingly connected world makes it possible for humanity to embrace a common destiny. As things stand now, economic globalization, application of information technologies, and cultural diversification are gaining greater momentum, and a new round of technological and industrial revolution is in the making. Countries are increasingly interdependent. Such developments bring about new opportunities for human beings. That said, risks and challenges such as wars, conflicts, poverty, epidemic diseases, and climate change are also on the rise. To advance the well-being of all humanity in keeping pace with our times, Chinese President Xi Jinping has proposed the initiative of building a community with a shared future for mankind. He called on the international community to work together to make the world a peaceful, tranquil, prosperous, open, and beautiful place. His community vision is endorsed and commended by many countries and people. An increasingly connected world makes it possible to promote and achieve greater openness and connectivity among countries. As our world is becoming a global village and the interests of all countries are more intimately intertwined, self-seclusion and isolation are out of place and will lead nowhere. Greater openness and closer connectivity represent the only viable way forward for a better future. This year marks the 40th anniversary of China's reform and opening up. China's development success is largely attributed to its opening up. An open China has contributed the largest share of world growth. In his keynote address at the Boer Forum for Asia Annual Conference last week, President Xi Jinping announced a number of significant measures to expand China's opening up. He reassured the world once again that opening up is China's basic state policy, and China's door will not be closed and will only open wider. This is a strategic move of China in light of the law of history and the general trend of our times. An increasingly connected world makes it possible for all countries to emerge as winners through cooperation. As members of the international community, our countries share a common future and a common stake in that future, and need to work together through the thick and thin. We need to develop win-win cooperation, which I believe is the right choice. China has initiated the building of the Belt and Road under the principle of achieving shared growth through discussion and collaboration. China's Belt and Road Initiative is to promote common development and prosperity through better connectivity of policies, infrastructure, trade, capital, and stronger people-to-people exchanges. The initiative is China's idea, but its opportunities and outcomes will benefit people around the world. In such an increasingly connected world, the Hague Conference can do a lot more. For example, it can help build a bridge between different legal cultures, remove barriers between different jurisdictions, and develop universally acceptable and applicable rules so as to facilitate international trade, business, and people-to-people exchange. This has long been the purpose of the Hague Conference. I hope and believe that the Hague Conference will continue to do so to help promote openness, connectivity, and win-win cooperation between countries. China is ready to work continuously with the Hague Conference to meet the challenges, seize opportunities, and promote the building of a community with a shared future for mankind. Ladies and gentlemen, we have a popular saying in Chinese, to get things done, one needs to have the right timing, the right place, and the right people. In Hong Kong, you will find all such favorable elements for a successful Hague Conference 125 celebrations. Hong Kong is an important hub in the increasingly connected world. I am sure you are already deeply impressed by its perfect mixture of Eastern and Western cultures, its dynamism, and its charming beauty. Thanks to the one country, two systems, the city known as the Oriental Pole enjoys the strong backing of the central government and serves as a gateway to China to the outside world. Its clean and effective government, complete legal system, and level playing field has made it the world's freest economy for 24 consecutive years. Hong Kong is an international financial, trading, and shipping center, and one of the world's most selected and popular cities for arbitration. Thanks to its strengths in law, Hong Kong provides world-class legal services for global business activities and dispute settlement. We are pleased to see the establishment of a regional office for Asia and the Pacific of the Hague Conference in Hong Kong, and we support the SAR government in strengthening cooperation with the office. In conclusion, I look forward to a free flow of ideas and to your vision and insights on the Hague Conference further development and on a shared future for mankind. I wish the conference a full success. The last but not least, also, I wish you a very nice stay in Hong Kong. Thank you very much.
Thank you very much, Commissioner Xie. Ladies and gentlemen, please now join me in welcoming the Honourable Chief Justice Geoffrey Ma. Chief Justice Ma was appointed the Chief Justice of the Court of Final Appeal on 1 September 2010. He was actually born here in Hong Kong, and was in private practice in this city and, well, in Singapore after acquiring his legal qualifications, training, and background in the United Kingdom. His profile may be found on page number 7 of the program, and I welcome Chief Justice Ma. Thank you.
Thank you for that. Dr. Bernasconi, Commissioners here, Secretary for Justice, distinguished guests, ladies and gentlemen, I too extend a warm welcome, in particular to those who have come from overseas. Much reference is made these days to themes of globalization and similar terms. The title of this conference uses the term increasingly connected world. It is, of course, appropriate to do so, but the significance of celebrating the 125th anniversary of the Hague Conference on Private International Law lies in the fact that these themes have been recognized right from the beginning of its history, and indeed represent the ideals and rationale for the continued existence of the HCCH. The founder of the Hague Conference, Tobias Asser, had this vision in 1893, and this was acknowledged in his receiving the Nobel Peace Prize, Nobel Prize for Peace in 1911. Asser was also instrumental in the formation of the Permanent Court of Arbitration from the First Hague Peace Conference in 1899, and he was also one of the founding members of the Institut de Droit International, the Institute of International Law. The TMS Asser Institute in The Hague is named after him. The premise of the HCCH is that a sound system of norms or rules of private international law, also known as the conflict of laws, fosters peace and stability among nations. Private international law features in almost every facet of human activity, and the HCCH has sought to achieve the harmonization of laws in relation to important aspects that have an international element, bearing in mind the underlying theme of comity. For our purposes, comity, an otherwise elusive word, especially for lawyers, can be defined as a recognition of the territorial relevance of other jurisdictions. As is reflected in the sessions of this conference, the HCCH has over the years, on the whole, but not exclusively, concentrated on family and children issues, international commerce and finance, and procedural matters. This is readily seen in the numerous conventions which have been the product of the work of the HCCH in fulfillment of Article 1 of the Statute of the Hague Conference, the progressive unification of the rules of private international law. I refer to some examples of this. In relation to family and children, the 1902 Guardianship Convention, the Hague Protection of Minors Convention, the 1980 Hague Abduction Convention. In relation to commerce and finance, the 1955 Convention on the International Sale of Goods, the 1958 Convention on the Transfer of Title in the International Sale of Goods, the 1958 Convention on the Selection of Forum in the International Sale of Goods, and in relation to procedure, the 1965 Hague Service Convention, the 1970 Hague Evidence Commission, the 2005 Hague Choice of Court Convention. There is an inherent acceptance in the work of the HCCH that the integrity and credibility of any legal system in a given jurisdiction is to a significant extent dependent on how that jurisdiction respects other jurisdictions, hence the importance of private international law. This is far from an academic exercise, as we can see from the importance of the way those topics of family and children law, international commerce and finance, and matters of procedure are dealt with. It is also dependent on the treatment of the aspect of fundamental rights. One is always anxious to know the extent to which any given jurisdiction pays regard to internationally accepted norms. In Hong Kong, the Basic Law, which sets out the constitutional position of Hong Kong as a special administrative region within the People's Republic of China, prescribes under Article 39 that the provisions of the International Covenant on Civil and Political Rights, the ICCPR, shall be implemented. The ICCPR thus finds legislative force in the Hong Kong Bill of Rights. In private international law, regard is had not just to fundamental rights domestically, but also to the extent that such rights exist and are in force in other jurisdictions when this is a relevant factor, such as in the context of the enforcement of judgments or in relation to questions of jurisdiction. In the course of my own legal career, both as a barrister and as a judge, I have seen that the approach of the courts reflects the spirit that the HCCH sets out to foster, namely, that the goals of justice and basically doing what is right can only be examined in a worldwide context and take into account the perspective of other jurisdictions. In an increasingly unpredictable and even volatile world, the work of the HCCH remains critical. I congratulate the HCCH on its 125th anniversary, but more than that, I congratulate the continuing work of the HCCH in meeting the many challenges it faces and to take the right opportunities in this complex world in order to meet them. Thank you.
Thank you very much, Chief Justice Ma. May I now introduce to you Ms. Teresa Cheng, the Secretary for Justice of Hong Kong SAR. Ms. Cheng was appointed Secretary of Justice on January 6 of this year, and prior to that, she was a senior counsel in private practice, a chartered engineer, a chartered arbitrator, and an accredited mediator. You may find her welcome message at page number 4 of your program and a profile at page number 8. Welcome, Ms. Cheng.
Thank you. Dr. Bernasconi, Commissioner Zhe, Chief Justice, distinguished guests, ladies and gentlemen. It is my great honor and pleasure to welcome you to Hong Kong and take part in this global conference in celebration of the 125th anniversary of the Hague Conference on Private International Law. The Department of Justice of the Government of Hong Kong has the great honor of supporting the Hague Conference through its regional office for Asia and the Pacific in hosting this global conference here in Hong Kong. It is only right that we pay tribute to the Hague Conference for its invaluable contribution to the developments of private international law in the past 125 years. Since its establishment in the late 19th century, it has grown into a global intergovernmental body with 83 members working zealously for the progressive harmonization of private international law. With the rapid expansion of cross-border transactions, mobility of people, and globalization generally, we would all benefit from the steady development of a clear and comprehensive international legal framework. The Hague Conventions facilitate these transnational activities and protect the interests of the people and the corporations through the provision of an infrastructure for coordination of laws, cooperation amongst courts and other authorities, and establishment of international norms. These developments are indispensable in an age of globalization for the pursuit of justice and the common good. Hong Kong is most privileged to have been chosen as the place for the Asia-Pacific Regional Office, With the establishment of the Asia-Pacific Regional Office in Hong Kong in 2012, the visibility and profile of the Hague Conference have been raised even further in the Asia-Pacific region. This is well illustrated by, for example, the joint ministerial statement of trade ministers of APAC economies in 2014, which welcomed the joint efforts of the APAC Economic Committee and the Asia-Pacific Regional Office of the Hague Conference. And I quote, it said, "To build awareness of private international law instruments to facilitate cross-border trade and investment, enhance ease of doing business, and foster effective enforcement of contracts and efficient settlement of business disputes." Hong Kong also hosted events organized by the Hague Conference in the region, such as its Asia-Pacific Weeks 2014 and 2015, its Global Conference on Child Support and Family Maintenance in Asia-Pacific and worldwide in 2015, and of course, this important 125th anniversary conference. The success of these events has clearly demonstrated the significant relevance and potential of the Hague Conventions on Private International Law for the Asia-Pacific region. After 1997, representatives from the government of Hong Kong SAR have been participating actively in meetings of the Hague Conference as part of the Chinese delegation. This is only made possible by Article 152 of the Basic Law, the constitutional document of the Hong Kong SAR. It provides that representatives of the government of the Hong Kong SAR may, as members of the delegation of China, participate in international organizations or conferences in appropriate fields limited to states and may express their views using the name Hong Kong, China. Indeed, Hong Kong's participation in the Hague Conference is one of the best illustrations of the successful implementation of one country, two systems, the policy that is enshrined in the constitutional law of China and the Basic Law. Currently, 9 Hague Conventions are applicable in Hong Kong. These conventions have served Hong Kong well in many ways, not just in the international context, but also in forming a framework for adaptation for the mutual legal assistance and arrangements that are put in place between the mainland and Hong Kong. For instance, the provisions and principles underlying the 2005 Hague Convention on Choice of Court Agreements have been adapted in devising a similar arrangement on reciprocal recognition and enforcement of civil and commercial judgments between Hong Kong and the mainland in 2006. There are a number of similarities between the Choice of Court Convention and the 2006 arrangement, such as the requirement of an exclusive choice of court agreement, the restriction to business case, and the limited grounds for refusal of recognition or enforcement. There are more examples. The Hague Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil and Commercial Matters has prompted Hong Kong to enter into an arrangement on the same subject with the mainland in 1999 and with Macau in 2017. We have also drawn on the experience of the Hague Evidence Convention when discussing with the mainland an arrangement on taking of evidence in civil and commercial matters between the courts of the mainland and Hong Kong SAR in 2016. Hong Kong takes great interest in the current judgment project of the Hague Conference, which seeks to facilitate a much wider international recognition and enforcement of judgments in civil and commercial cases. As confirmed at the meeting of the governing organ of the Hague Conference in March this year, good progress has been achieved. Arrangement is being made to prepare for the final Special Commission meeting next month and a diplomatic meeting in mid-2019 to conclude the project. With the support of the Central People's Government, Hong Kong has been actively participating in this project as part of the Chinese delegation. The future instrument to be adopted under the judgment project would complement the choice of court convention and would help further enhance the utility and efficiency of cross-border dispute resolution. The international experience will no doubt inspire and encourage the finalization of the arrangement for mutual recognition and enforcement of judgments between mainland and Hong Kong. After conclusion of the judgment project, the promotional and post-convention work are indispensable in order to ensure early entry into force and successful implementation of the instrument. In this regard, Hong Kong would be able to play an important role in the promotional and capacity building work in this part of the world. Apart from the judgment project, there are also other areas of private international law which may warrant further work by the Hague Conference, whether in the spheres of commerce and trade or of persons and families. We look forward to working closely with the Hague Conference and the international community to further these projects. The theme of this conference, Challenges and Opportunities in an Increasingly Connected World, is timely. No jurisdiction or region stands alone or can stand alone in this time of increased interconnectivity. Integration, harmonization, and connectivity are attributes that underpin a modern world of peaceful coexistence. The Belt and Road Initiative promotes connectivity in 5 areas: policy, infrastructure, trade, finance, and people connectivity. In respect of each of these areas, aspects of conflict of laws will no doubt have to be properly addressed and considered. The Chinese word for crisis is 危机. Wei and ji connotes 2 concepts: challenges and opportunities. Do we have a crisis? We obviously have challenges that is facing us in the increasingly connected world, as the theme connotes. However, with challenges, we will also have opportunities. With the discussions amongst the experts from different regions that are to be conducted in this conference, I have confidence that we will all benefit from the legal analysis, so much so that we will not only identify and rise to the challenges, but will convert them into opportunities. Hong Kong, as Asia's world city, prides itself in our mission to connect and excel. This conference will further Hong Kong's policy to be an international legal hub and dispute resolution center. Ladies and gentlemen, Hong Kong would continue to play an instrumental role as a springboard for the Hague Conference to further develop its work and extend its influence in the region. With a view to enhancing harmonization of private international law in this region and beyond, to promoting the rule of law at an international level, and to the furtherance of peaceful coexistence, we will strive to give full support to the Hague Conference's work through the Asia-Pacific Regional Office here. On this note, may I wish the Global Conference every success, and for those coming from overseas, an enjoyable stay in Hong Kong. Thank you very much.
Thank you very much, Secretary Cheng. I'm now pleased to introduce our next officiating speaker, Dr. Christophe Bernasconi, the Secretary General of the Hague Conference on Private International Law. Himself a leading expert in private international law and international civil procedure, Dr. Bernasconi took office in 2013, and may I say, was recently reconfirmed by the membership for a further term, after he joined the Permanent Bureau in 1997. He works tirelessly on focusing and furthering the initiatives of the Hague Conference and stirs it strategically. You may find his welcome message at page number 4 and his profile at page number 8 of the program. Welcome, Dr. Bernasconi.
Mr. Feng, Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong SAR, the Honourable Chief Justice Geoffrey, Mrs. Teresa Cheng, Secretary for Justice of the Hong Kong SAR, distinguished delegates, ladies and gentlemen, dear friends of the HCCH who heeded our call to gather here in Hong Kong, the Oriental Pearl, for this unique conference. A conference indeed which we designed not so much to look back at past achievements of the HCCH, but in particular to look ahead, to try to imagine and maybe understand what's coming our way and what it all means for private national law and the HCCH in the future. So let's try this. 6,501 weeks. Fast forward 6,501 weeks into the future. What's happening? It's bad news. It's a world without lawyers. On a positive note, accountants are gone too. Computerized judges, computerized justice, a world dominated by artificial intelligence. Beautiful, objective artificial intelligence soaring above messy, subjective human factors. AI is drafting laws. Hey, AI is drafting Hague Conventions. No more squabbling about what consensus means. AI is consensus. Daunting, I know. Maybe even a tad irritating, but impossible? Let's jump back 6,501 weeks, back to Tobias Assel, the founding father of the HCCH. It's September 1893, 125 years ago. He is sitting at his desk preparing his inaugural address for the first diplomatic session of the Hague Conference. The electric light, the electric telephone, the ballpoint pen, metal detectors, diesel engines, zippers, all these things, amazing things and much more had just been invented. Everything seems possible. It's euphoria. Assel sees these technological marvels and the related changes, and he plans his bold call. He sees it all: increased travel, mobility, connectivity, trade, opportunities. All this is transforming individuals, communities, societies. Nothing like this had ever happened in human history before. The law must keep up, he says. Private international law must keep up. To help people do new things, support new ideas of freedom. Within international borders, but especially across those borders. Assel sees that law helps the world manage tumultuous change. It gives trust. It provides certainty. Does Assel look ahead, forward 6,501 weeks to our world 125 years later? Does he imagine 2 world wars? The great European empires that defined his world? Civilization itself, as he saw it, gone. Assel can't imagine flying machines, jet engines, or rockets. Insect drones coming down our chimney, controlled from thousands of kilometers away. And he certainly can't imagine millions of cat videos on YouTube. Or colleagues in Argentina, South Africa, or Saudi Arabia watching this conference for free on small handheld gadgets. His world, Assel's world, measures assets by some sort of gold standard. How to imagine distributed ledger technology, blockchains if you prefer, through which assets can be transferred instantaneously across borders, making extensive use of cryptography. Invisible assets, almost abstract. That's where we are now. How about 6,501 weeks from now? It's back to the future. The Hague Conference's 250th anniversary event in 2143. Will the law keep up? Change with times? Help people do new things in new ways within and across borders? What will borders actually mean? What will universality mean? Here on Earth? What about space? Why has the HCCH survived through its first 6,501 weeks of revolutionary changes in technology and global order? Cynics might say that the HCCH survives simply because it's too small to be noticed. The HCCH is cheap, absurdly cheap. A budget of 4.2 million euros a year, an accounting rounding error for global development programs, a trivial fraction of litigation costs in the world's main jurisdictions. It's more expensive to get rid of the HCCH than to keep it alive. But people who aren't cynics know that what we collectively as an organization do is more than useful. It's important. In fact, it's essential. Private international law is oil in the world's engine, smoothing things along. Family issues, business, e-business, innovation, privacy, big, tough issues with huge, immediate, complex cross-border implications for policy, for people, for businesses. So we do fulfill Husserl's ideal. Trust and certainty are more precious than ever. So far, so good. But there are challenges ahead. For example, we talk universality, but we haven't kept up with the growth of new states. As this century gets into its stride, one thing is clear. In 6,501 weeks from now, a large proportion of the planet's young people will be in Africa. Their energy and ingenuity will need trust and certainty. We need to bring scores of African and Middle East nations into the HCCH framework in the coming decades. More regional offices would help, even if it's tough, complicated, budget and stuff, you know. Also, as the Hague Conference's reach gets bigger, does it otherwise not change much? Should it not look to complement reliability and steadiness with at least some degree of new flexibility? Asymmetric consensus, as I like to call it. Maybe not everybody needs to agree on or work on new legislative projects or do so at the same time. Making space for those who want to experiment, go further, and maybe change things faster. But how to make the case for smart, global unification while at the same time encouraging new initiatives that in fact create new diversity and different paces? It's not easy. Also, and maybe more importantly, let's not make perfect the enemy of the sensible. Why not look for smaller, practical, common sense, easy wins and take it from there, building blocks? To some extent, we have started to do that. We see it in ourselves, our homes, our jobs. Everything is speeding up, becoming lighter, more nimble. Back in his famous 1862 address on commercial law and commerce, Husserl proposed an international convention. Yes, on mutual recognition and enforcement of foreign judgments. Next year, finally, his dream comes true. A mere 157 years later. Can't we do better than this? Can law itself stay credible if it creeps along at this pace? Like an elderly snail, with a bad leg, that is? I can't answer all these unsettling questions, but I do have an invitation. I invite you, use this gathering, play with ideas, think differently, think strategically, think boldly. I would like to see this free flow of ideas, as Commissioner Sen put it. maybe 6,501 weeks from now, that would be April 2143, is just too far ahead to imagine. So let's focus instead on just 1,100 weeks from now. That's 20 years. 2038. Many of us will still be around, we hope. Will we look back on this event and say, yeah, Hong Kong, well, it was just another costly conference. Nothing really happened. No one cared. In fact, I hardly remember it. Or will we say, yes, Hong Kong 2018 was something. It made such a difference. It helped setting the HCCH on its new path that's doing so well. I'm so pleased, in fact, I was there to play my part in making new things happen. Colleagues, friends, things that seem impossible to us lawyers today will be commonplace to our children and grandchildren, whether we like it or not. What do we do about that change? Embrace it, encourage it, champion it, or stand in the way? Tobias Asser was wise and bold in 1893. We respect his memory best by being wise and bold ourselves. We look back with pride, respect the precedent of yesterday. We look forward with confidence, embrace the promise of tomorrow. Today, we end our first 6,501 weeks. Today, we start the next 6,501 weeks. The HCCH has grown from strength to strength. Let's make sure we get to the next level. Thank you.
Thank you very much, Dr. Bernasconi, for this very inspiring speech indeed. That concludes, ladies and gentlemen, the opening session of this conference. And we will go from strength to strength right now by reaching the keynote speech, the keynote address, which will be given by Professor Jürgen Basedow. Professor Basedow almost needs no introduction to anyone here. He's the director, or former director, of the Max Planck Institute for Comparative and International Private Law in Hamburg, a German legal scholar, and his main field of research focus on private international law, on European private and commercial law, with an emphasis on competition, transport, traffic law, as well as insurance law. He has an exceptional academic career, and you may find his profile at page 9 of the program. Ladies and gentlemen, please welcome Professor Basedow to the stage.
I'm fine. Honourable dignitaries, excellencies, distinguished colleagues, ladies and gentlemen. Anniversaries are days of remembrance of the past, of assessing the challenges of the present, and of contemplating options for the future. My paper is dedicated to these three perspectives. Let me start with the past. The 125th anniversary of the Hague Conference, with its name so uncommon for an international organization, draws our attention to the second half of the 19th century. What was the situation like that gave rise to the first Hague Conference convened by Tobias Asser in 1893? It can be encapsulated in some keywords. First, the rise of the bourgeois society to its climax and highest perfection.
the outline would be fine if you could put. Yeah, I can put that. Oh. We have an outline, so so that you know how much you will have to wait for the coffee break. That's it. Mm-hmm. So, several points which encapsulate the situation of the second half of the 19th century. First, the rise of the bourgeois society. The second one is the positivistic belief in the ability of mankind to perceive and shape all conditions of life. The third is the assertion of the nation-state as the ultimate point of reference of human societies. The fourth is the Eurocentric order of the world. And the fifth, what I call the first wave of globalization. The general features of the time have left their traces in the legal landscape at large and in private international law in particular. Thus, positivism and the growing role of the nation-state account for the codification movement that had only few followers in the common law world, but prevailed on the European continent and in Latin America. Excluding recourse to any prior law, in particular to Roman law, the codes highlighted the territoriality of and the divergences between national private laws. They became an obstacle when cross-border migration and commerce, triggered by the Industrial Revolution, evolved quickly in the second half of the 19th century. This was perceived in present terminology as a first wave of globalization. The need for conflict rules had previously only existed with regards to scattered local provisions. It was now increasingly appreciated as urgent. With a view to continuous legal harmony of decisions, and at the initiative of the Italian scholar and politician Mancini, the Institut de Droit International launched the proposal for a uniform private international law to be shaped in international treaties. The first implementation of this proposal occurred in Latin America, in the treaties of Lima in 1878 and of Montevideo in 1889. While these conventions were confined to Latin American countries, the Hague Conference, convened in 1893, was an exclusively European event. However, over time, the Hague Conventions became influential beyond the shores of Europe. That is due, or was due, to colonialism. Apart from China, Japan, Thailand, and Ethiopia, the Eastern Hemisphere, under European dominance, was inclined to consider European achievements as models of societal progress. It was not before 1904 that Japan, as the first non-European country, attended a Hague Conference. Nevertheless, the conferences essentially remained European events until the end of World War II. In 1951, 15 European countries, including Great Britain, and Japan founded the Hague Conference as an intergovernmental organization. By and by, some countries of the Western Hemisphere, such as the United States in 1964 and Argentina in 1972, joined, but the European countries kept their programmatic influence as evidenced by the ratifications of conventions. The Eurocentric character of the Hague Conference was finally challenged when the European Union took over from its member states the legislative competence for private international law in the Treaty of Amsterdam of 1997. Thereby, the Hague Conference lost its main geographical field of action. But it has made great efforts to keep track of globalization and to attract new members from other continents. This has been very successful. Since the year 2000, more than 30 states from outside the European Union have acceded to the Hague Conference, most of them from non-European countries, the most recent accessions being those of Saudi Arabia and Kazakhstan. The transition of the Hague Conference from a Eurocentric to a universal organization is mirrored, facilitated, and promoted by changes that emerge from a comparison of the old conventions adopted before World War I with the conventions concluded after World War II. The old conventions, just like the Latin American counterparts, were exclusively intended for reciprocal application between states represented at the respective conference. They created a special regime for interstate relations within a closed club. No other states were admitted until special protocols adopted in the 1920s allowed for their adhesion. The post-World War II conventions generally enable states not represented during the negotiations to accept the binding character of the resulting convention by accession, adhesion, or approval. Now, the Hague Conventions are basically open. And many of the new members have in fact made use of this possibility to join, thereby gaining positive experience with Hague instruments. A second change is the abandonment of reciprocity with regards to choice of law. The modern conventions are what we call lois uniformes, that apply regardless of whether the designated law is the law of a contracting state. Thus, contracting states need not care for national choice of law provisions in the respective field. By giving effect to the convention, they introduce a national regime which at the same time ensures conformity with international standards. I turn to cooperation mechanisms. No? That's good. Yeah. As the cross-border movements of persons, goods, and capital are intensifying, the need for effective judicial cooperation between states increases. It includes all issues of procedural practice, from the service and legalization of documents, across legal aid, the security for legal costs, the procurement of evidence, issues of translation and assessment of foreign law, to jurisdiction and the recognition and enforcement of foreign decisions. Many of these subjects have been dealt with by Hague Conventions. They have received a large number of ratifications and accessions, indicating the demand of the international community. About 100 in the case of adoption cooperation and child abduction, even more in the case of legalization of public documents. Other instruments on civil procedure, on the service abroad of documents, and on the taking of evidence in foreign countries have attracted between 50 and 75 states and still demonstrate their strong interest in judicial cooperation. The explanation for this success is simple. The judiciary in any country cannot avoid the problems that arise where a statement of claim has to be served in a foreign country, where evidence is located abroad, etc. These problems require communication in foreign languages and unknown formalities, and are often perceived as troublesome by the judges and government officials involved. They know that the solution depends on the foreign court's cooperation. There is an inherent element of reciprocity. If you help me, I promise to help you. And if you decline to help me, you cannot expect me to provide assistance to you in a similar case. A convention somehow channels the activities needed and formalizes the promise of reciprocity. It can be predicted that instruments on judicial cooperation will attract the approval of states also in the future, to the extent that they target complex problems which the courts of one country are unable to escape and to resolve on their own. The recognition and enforcement of foreign judgments appears to be the ultimate and most far-reaching form of judicial cooperation between states, although enforcement applications at present are no longer lodged by the foreign court or state, but by the winning party. Nevertheless, the element of reciprocity still surfaces in some states, such as China, Germany, or Japan, in explicit provisions requiring the ascertainment of reciprocity as a condition of enforcement. A multilateral treaty might therefore appear to be a welcome solution. Yet, among the Hague Conventions in this field, the only ones that can be considered as successful are those dealing with very specific areas of family laws, such as inter-country adoption, parental responsibility, or, to a lesser extent, maintenance awards and divorce decrees. But to date, no instrument of general application to civil and commercial matters has had much effect. The 1971 Hague Convention did not succeed to overcome the traditional bilateral treaty making in this area. Thus, in the field of commercial law, there is a surprising contrast between the great success of the Brussels and Lugano Conventions in Europe and the absence of a workable multilateral regime for the rest of the world. What are the reasons? Is the enforcement of foreign arbitral awards under the New York Convention sufficient for the needs of international commerce? If not, will the Hague Judgments Project fill the gap? First, the significance of claims enforcement for international trade is usually underestimated. Trade treaties such as the GATT or preferential trade agreements are state-centered. They regulate quota of importation and exportation, tariff rates, non-tariff regulatory barriers to trade, etc. That is, the behavior of governments involved. They do not take account of the fact that within the margin created by these trade treaties, the major part of cross-border trade is in the hands of private undertakings and not of public entities. The trust of private actors, especially smaller ones, inter alia, depends on the availability of claims enforcement. However, the people negotiating the Hague Judgments Convention have little contact with the officers of their own governments who are responsible for international trade. The representatives of both sides appear to act like strangers in the night. This has always been the case, with the single exception of the Rome EEC Treaty of 1957. The objective of the common market included the customs union as well as the removal of quotas and regulatory barriers. In this respect, the EEC Treaty was a trade agreement. In the last phase of negotiations, the delegations became aware that for the implementation of the common market, the confidence of the private market participants in claims enforcement plays an important role. They added Article 220, which, among others, tasked the member states to negotiate a convention on the mutual recognition of judgments. This is the historical origin of the successful Brussels Convention and of the present Brussels Regulation. The lessons that can be learned is that cross-border trade and the enforcement of foreign claims are interrelated. Therefore, states should promote the mutual recognition of judgments in the interest of the increase of cross-border exchanges. Commercial arbitration and the enforcement of foreign arbitral awards is not enough, since arbitration is not available for many disputes, in particular the ones turning on non-contractual claims and those with low values. Second, states, as compared with other areas of judicial assistance, are less incentivized to engage in multilateral recognition treaties. Here, the situation of courts and governments differs. The enforcement of a foreign judgment is in the hands not of public applicants, but, as I said, of private parties. Neither the court addressed nor the government and the state of enforcement are involved in the enforcement of their own judicial decisions in the country of origin of the foreign judgment. Thus, the judiciary does not dwell in the intricate situation that I have described above in the context of other forms of mutual assistance. The consequences of non-enforcement are borne by private parties, not by states, and not by the judiciary. It follows that their incentive to conclude and give effect to an international enforcement treaty is not the same as in other fields of judicial cooperation. Third, the administration of justice does not have the same quality in all countries. There is no point in pretending. In certain countries, judges lack independence or income or both. As a consequence, they are amenable to bribery and their decisions are biased. States with a high esteem of the rule of law will not want to give effect to judgments coming from those countries. As a matter of diplomatic politeness, their governments do not address this issue at the stage of negotiations. Thus, the draft Hague Convention at present does not hint at this problem, contrary, for example, to the Uniform Foreign Country Money Judgments Recognition Act of 2005 in the United States. This act clearly rules out the recognition of a foreign judgment, quote, rendered under a judicial system that does not provide impartial tribunals or procedures compatible with the requirements of due process of law, unquote. The preoccupation emerging from these words is not alien to governments in other countries. It is not voiced in public, but it will be decisive in the internal discussions at the stage of ratification unless the convention provides for some safety valve. In a recognition treaty that is open for worldwide accession, the contracting parties should be permitted to avoid for themselves the effects of a future accession to by its non-acceptance, similar to what has been agreed upon in the Child Abduction Convention. This is, however, not enough. Contracting states should, moreover, be allowed to exclude the application of the instrument in the relationship with specific contracting states. This is a very delicate issue, since states are usually reluctant to make any kind of negative statement about other states. More compatible with diplomatic habits might be allowing states declarations that they would apply the convention only in relation to contracting states contained in a positive list, thereby implicitly excluding the recognition of decisions from other jurisdictions. Such declarations should be limited in time, requiring a review and eventually a renewal when that time has elapsed. Without such a safety valve, the Hague Judgments Convention is unlikely to attract a large number of ratifications. I skip my following section on jurisdiction, I simply would like to point out that in my view it is possible to agree on jurisdiction with regard to specific subjects, such as parental responsibility or choice of court. But for various reasons it will be very difficult to agree on a general convention regulating jurisdiction. I have in my paper some proposals for future cooperation projects, which I would like to summarize here. Most important, especially in connection with the judgment project, would be a kind of post-convention service. Judges have to meet each other, judges from different countries, in order to reduce the suspicion that the other side is perhaps less qualified or less willing to cooperate. As for the legislative projects, I would like to recall that ever since the 1980s, there has been an incredible rise in foreign direct investment. This means, in the terminology of private law, companies, and in times of crisis, insolvencies. These two areas should be targeted by the Hague Conference. I do not believe that in company law it will be very easy to get to an agreement, but one should try. With regard to insolvencies, of course, one would have to consider the cooperation with UNCITRAL, since there is this model law on cross-border insolvencies. Similar is the situation with regard to arbitration. In arbitration, we have quite a number of issues which are not regulated by the UNCITRAL model law and neither by the New York Convention. This again would be something for the Hague Conference in cooperation with UNCITRAL. An area which so far has not been targeted by any international organization are the cross-border aspects of class action, of collective redress. So far it was mainly the United States where this type of action existed, but more and more we find laws of this kind in some European countries, such as the United Kingdom and Belgium, and the European Commission has now proposed something on class action, so that might be good to tackle the international aspects of that. As far as small claims are concerned, a similar subject would be the international aspects of alternative dispute resolution. Let me turn to choice of law. In the history of private international law, the predominant issue in academic writings was the choice of the law governing a legal transaction. A look at the status tables of the various Hague Conventions shows, however, that choice rules are not appreciated outside Europe. For this purpose, the numerous package conventions that contain both cooperation rules and choice rules should be distinguished from the pure choice of law instruments. Among the latter conventions, only the one dealing with the form of wills has received noteworthy approval in non-European countries. 14 out of 42 contracting states are located outside Europe. But the number of non-European parties to other pure choice of law instruments, such as the one on traffic accidents, on products liability, or on maintenance obligations, is next to nil. The finding certainly gives evidence of an underassessment of the role that unified choice rules play for legal certainty, that is, for the predictability of the outcome of disputes and for the planning of legal relations. Nevertheless, it is also a warning to the Hague Conference. Wherever possible, the conference should frame its future instruments as package conventions, including both cooperation rules and choice rules. This may attract approval from non-European countries, which is urgently needed, since exclusively European conventions will be superseded by EU regulations and are therefore redundant. An alternative might be the adoption of non-binding principles or model laws that signal a certain regulatory need and at the same time provide an internationally approved blueprint while leaving some leeway to national legislation. Again, I shall skip or summarize my ideas about future legislative projects. I have already referred to the law governing corporations. Another area where perhaps some success could be possible is the law of property rights. I'm not thinking of this in general, but as the Hague Securities Convention has shown, successful texts in this area should focus on specific points, specific subjects. For example, the law applicable to cultural objects, the art market is flourishing all over the world, or the retention of title in the cross-border sale of goods. What I think is of a far-reaching significance, perhaps over 6,501 weeks, is the law relating to overriding mandatory provisions. Ever since 1978, international instruments have embodied the concept of overriding mandatory provisions, that is, rules of a legal system that require application irrespective of the law otherwise governing the legal relation in question. Such provisions usually establish their own scope of application by unilateral scope rules. Analogous provisions of legal orders other than the governing law may be given effect where a close relation with the case at issue can be ascertained, but that is in the discretion of the court. The concept is most clearly spelled out in the Rome I regulation of the EU. The international instruments usually neither identify the provisions in question nor determine their scope of application. Both is left to national law. Thus, the respective provisions of the international instruments are not more than vague reservations, but they endanger the workability of the bilateral conflict rules of the Convention, where the court applies the overriding mandatory provisions of the forum. The uniformity of outcome is usually excluded. The existence of such general reservation is an invitation to national legislatures to declare new mandatory laws as overriding and to determine a wide scope of application. That is what happens more and more. States tend to declare their own policies to be absolute, not only in the domestic context, but also in the international setting. This is usually designated as an extraterritorial application. An early case was the application of antitrust laws under the so-called effects doctrine. More recent examples can be found in capital market law and in data protection. In capital market law, the listing of securities in a domestic market, a stock exchange, and other connections with the forum state are used as a lever for the imposition of information duties on foreign companies. The new General Data Protection Regulation of the European Union inter alia applies to the processing of data in any country of the world by so-called data controllers from non-European countries, provided that the data subjects, as it is said, are in the Union. The US government, on its side, currently puts pressure on Microsoft Corporation and other companies established in the US to get hold of data stored on servers located outside the country, in particular in Ireland. In all three areas, territorial measures of public enforcement go hand in hand with an extension of the scope of application of the relevant laws in private enforcement to extraterritorial fact situation. Since such developments challenge the operation of bilateral conflict rules, they deserve closer attention in the future. The evolution of international competition law is instructive. What used to be an entirely unilateral approach in the beginning does not exclude a later turn to bilateralism when a certain approximation of the substantive laws occurs. In fact, the gradual proliferation of antitrust laws from the US, first to Western Europe and gradually across the whole globe, nowadays allows for the application of foreign antitrust laws in civil litigation. And both the Swiss law on private international law of 1978 and the Rome II regulation of the EU contain conflict rules that in appropriate situations may designate foreign competition law. What has happened in antitrust law may also be achieved in other areas. What is needed is a precise functional comparison of the substantive laws of the various jurisdictions. Do they really differ that much, or do they provide equivalent protection? We further need a check of claims of extraterritorial application in view of what has been called negative comity. Is every policy pursued at home absolute in international relations? A third basic issue concerns the relation between public and private enforcement. Should the extraterritorial extension of the scope of a law for the purposes of ex-ante public enforcement generally be transferred to private enforcement, for example, as it is done in the European Data Protection Regulation? A fourth point, resulting from the others, could be the basic inclination to give effect to foreign legal rules in the field at issue which pursue similar objectives. Much research and discussion is required. The Hague Conference could provide a platform for such activities. Now, I summarize my part on the impact of human rights, which is a very European subject. In Europe, individuals have a right of complaint to the European Court of Human Rights, and they, for the last 20 years or so, they have made use of that also in issues, in cases involving private international law. So we have quite a lot of case law in this area, which is, however, not to be understood, as I interpret it, as replacing private international law. It is rather giving an impulse for a reconsideration of rules on private international law. And I want to give you an example for that, which is surrogate motherhood. Surrogacy is prohibited in some countries, but lawful in others, sometimes subject to certain procedures. In light of the prohibition in their own state, would-be parents from the former countries often enter into surrogacy agreements with women from the latter countries. For example, California or Russia, or as I recently heard, Laos. When the child has been registered in the country of birth as the child of the intended parents, the couple will usually take the child to their country of residence and lodge an application for the recognition of the foreign birth certificate. Now, is the dismissal of such application based on the prohibition of surrogacy a violation of human rights? The European Court of Human Rights has answered this question in the affirmative with regard to the child's right to respect for private life. But there were other cases where the court has given a negative answer. The Hague Conference has started work on this matter. It considers the issue as one of recognition of a personal status acquired abroad in accordance with the law of the foreign country. The case law appears to endorse a principle of recognition, perhaps mitigated by some restrictions that is imposed by human rights law. But adjudication ex post is different from legislation ex ante, and when it comes to the convention, to the ratification of a convention, this would be a case of legislation ex ante. A principle of recognition enshrined in a treaty would have difficulty to overcome at the stage of ratification by states the strong political opposition against surrogacy that is existent in many countries and that is motivated by socialist, by feminist, and by religious policy considerations. Viewing the relation between the states as one of supply and demand might yield better results with a view to the future approval of a binding instruments by states from both sides. It would require a regulation that transcends the ex post perspective of recognition. It should establish procedural arrangements following, for example, the Uniform Parentage Act in the United States. That act requires a check of the intended parents with regards to their physical, medical, social aptness, and a check of the gestational mother in respect of her age, her health, her free will, and her ability to give birth to a child. Such checks could be carried out on behalf of central authorities in the countries involved. Following the cooperation pattern established by the Inter-Country Adoption Convention, the central authorities would communicate with each other and benefit from the other's knowledge. Thus, inspiration could be gained from the American Uniform Parentage Act and the Hague Adoption Convention taken together. The resulting Hague instrument would be a package convention as outlined above. I come to my last part on institutional recommendations. The Hague Conference emerged as an intergovernmental event and later organization at a time when states appeared to be the sole and almighty framers of human societies. International private relations could only be ordered by allocating competence to one of the states involved. The allocation method helped to increase legal certainty in the interest of private actors and to affirm the sovereign powers of states by recognizing their national private law. Is this model still appropriate to explain the current situation? In light of the more recent developments, institutional modifications suggest themselves. In several areas, the allocation method has been supplemented by the unification of substantive law promoted by numerous international organizations, some of them with a sector-specific, other with a general purview. The overall legal framework should, however, be consistent. Substantive law and private international law dealing with the same sector should be adapted to each other. This requires a close cooperation of the organizations involved that has already been put into effect in some cases. The all-embracing sovereignty of states in respect of social ordering has in reality also ceded to a mix of influences exercised by social and economic groups on the one side and public administrations on the other. The Hague Conference might be better off if it establishes for certain projects advisory committees that permit organized group interests to voice their concern at an early stage. This is particularly important where specific subjects are treated which involve groups representing homogeneous interests. This proposal may also help to include the Islamic world into the deliberations relating to personal status, family relations, and succession law. In Europe and the Western world, secularization has subjected these areas to state law. But one cannot close the eyes that they are under strong, in some countries of the Middle East and Asia, even exclusive influence of religion. Governments from those states are therefore not interested in Hague deliberations on matters of personal status, although Muslims are very much involved in cross-border migration as well. The Hague Conference should try to open channels of information and discussion with the Islamic world, also in the field of personal status and family law. The suggested advisory commissions could serve this purpose. Further recommendations relate to the growing number of members of the Hague Conference. Some of the new member states have little experience in private international law and, more generally, in the administration of a judiciary working under the rule of law. They need advice on the publication of legislation and jurisprudence, and their judicial personnel needs training in conflict of laws which is not available in their respective country. The Hague Conference should initiate, perhaps together with other international organizations, capacity building programs which are geared towards the formation of judiciaries that are able to handle the legislative texts approved by their governments. Finally, the anniversary draws our attention to the problem of aging conventions. The Hague Conference should consider ways of simplified amendment of its instruments. The need for a ratification of every amendment in practice is conducive to either the disintegration of uniform law that occurs where not all contracting parties of a basic convention ratify an amendment, or to the petrification of outdated rules that results where the contracting parties abstain from an amendment that would appear appropriate in light of changed circumstances. Simplified amendment procedures are, of course, confined to very specific points, but they are needed and they exist in various forms in other sectors of uniform law. Let me conclude. 125 years ago, the Hague Conference took off as a Eurocentric undertaking of a dozen states with similar legal and cultural traditions. It has been a long way from there to the present worldwide organization with more than 80 member states from very divergent legal and cultural backgrounds. While the conference still faces the same basic problem, that is the coordination of different legal orders, the institutional environment has undergone profound changes. The Hague Conference will have to adjust by the institutional changes outlined above and by focusing on universal instead of European demand. It has to address the universal need for cooperation rules and for what I have designated as package instruments. Its future task is not only the coordination of state behavior, but the service to an international private community that is in need of legal certainty in a world that allows for global movements impaired by divergent territorial laws. Thank you very much.
Yes, thank you very much, Professor Basador, for this wide-ranging and very detailed expose. Now, ladies and gentlemen, we are just about to break for coffee. But before we do so, and I know this is a very dangerous move, I ask you for two things. The first is that we thank Commissioner Xie, the Chief Justice, the Honourable Chief Justice Ma, the Secretary for Justice, Ms. Cheng, the Secretary General of the Hague Conference, as well as Professor Basador, for this officiating session, as well as the keynote address in the customary way. So if I may ask you to sit down. The second is just a very brief overview of what is going to happen now, because I ask you to not only leave this room, but also to assemble outside in the gardens to have the group photo taken. Now, this is a little bit of a walk back to probably where you all arrived, downstairs, but no, don't fear. There's plenty of students that will guide you. I think Nicole and Edwin, both are waving up there, will be looking after you. So if you follow those two, you will not be lost and you will find yourself on the group photo. However, if I may just ask the first row to remain seated and stay back with us for an official photo just in front of this here, that would be fantastic as well. Thank you very much, and I will see you for the coffee break downstairs after the photo. Thank you.